Hello, I want to welcome everyone to this Brown Brag today. We appreciate the Shriver Center coming in to talk to us, and I want to talk just a little bit about why they're here and what we're doing, right? I'm Ron Ashford. I'm on the Reentry Council. HUD is part of the Federal Reentry Council. So as a result of that, I go to a lot of meetings with folks who are coming out of prison and talk to a lot of different groups and hear stories from a lot of different groups. And I want to tell you one sentence that has stayed in my mind. And that is, someone said, you know, when you're convicted of a crime, it's a lifetime sentence. And that caught me, because lifetime sentence, so that you went to prison, you did your time, and it could be you're on probation, you did a 6-month jail stint, you did a 5-year jail stint, you did a 20-year jail stint. Doesn't matter. When you come out, every time you go to get a job, there's a box you check. Have you ever been convicted? Lifetime sentence. When you try to get a driver's license in a lot of states, you got to check the box. Lifetime sentence. In some states, you cannot be a barber because you were in prison, right? In other states, you can't be this or you can't be that because you were convicted. And again, it doesn't matter how much time you did, right? So that's something, the lifetime sentence stuck in my mind. So there's another area, and the area is housing. So that if you are trying to get into housing, public housing, multifamily housing, you have to check the box. And you are interviewed and you're talked to. Most housing authorities, or many housing authorities, have time. Okay, if you did this crime, we're talking 3 years or 5 years, or there's some varying degrees. Some housing authorities, however, say if you've ever been convicted, you cannot live in public housing, period, right? It happened when you were 23. You're 55 now. You still can't live there. So this is something that it hurts. It hurts me as a HUD person, and I think it hurts all of us. So the Reentry Council has done some things, and one of the things we did do was we got the secretary 4 years ago to send a letter out to all housing authorities and all multifamily agencies that said, here's HUD's position. And HUD's position is there are 2 permanent debarments. 1, makers of methamphetamine on the property, and 2, if you're on the sexual registry list. Those are the 2 HUD debarments. Everything else is left up to the local public housing authority. So we sent this letter out to 3,200 housing authorities, and we sent it out to multifamily agencies. And, you know, it's a letter, but because of that letter, housing authorities began to move in the direction of, what can I do? Because in the letter, Sean Donovan and Sandy Enriquez said, we encourage you to look at your policies and, where possible, do some things in this area. And it's because of that sentence that some things are being done. But we know we have a lot more to do. And we look to people like the Shriver Center, who have done some research in this area, to inform us about what it's like, what can be done, where can HUD move, because they have actually looked at housing authorities and some of our regs and some of our regulations. So I'm very happy that they're here. I encourage people to listen, raise comments, debate, no, we disagree, or yes, we agree. I encourage all of that. We encourage all of that, right? So with that, I will introduce Kate Walz and MCTL, and she'll tell you what that means because I couldn't remember it. So Shriver Center, please come up. And can I get some applause for them? Please. Great.
I'm Kate Walz. I'm the Director of Housing Justice at the Sargent Shriver National Center on Poverty Law in Chicago. I'm here with my colleague Claire Tran-Leung, who is the author of this report, When Discretion Means Denial. And so she's going to talk to you about the sort of, go through the report. I'm going to give you sort of an overview of today's discussion. So we're going to talk about criminal records, public safety, homelessness, and HUD. and the role that HUD plays within all of this. We're also going to talk about the statutes governing criminal records in federally subsidized housing and criminal record screening, and the 4 major ways that public housing authorities and project-based Section 8 owners currently use the discretion that they have to deny admission to people with criminal records. This is actually a follow-up from a 2011 report that we did looking at project-based Section 8 owners and public housing authorities in the state of Illinois. And we found, which Marie-Claire will talk about, some pretty startling outcomes, that they were outright denying people with any type of criminal history, even a mere arrest. So we asked ourselves, is the same problem on a national level, or is this just an Illinois problem? So I won't give away the ending. I'll let Marie-Claire tell you that. And then we're going to talk about suggestions for HUD to take active steps to ensure that public housing authorities and project-based Section 8 owners use their discretion to admit people with criminal records where appropriate. So criminal records and public safety. There is currently no empirical evidence establishing a relationship between a criminal record and an unsuccessful tenancy. On the other hand, housing instability is significantly associated with recidivism. In a Georgia study, every time a parolee changed his or her address, his likelihood of being rearrested increased by 25%. There's also ample evidence that incarceration is a risk factor for homelessness and vice versa. Because of this mutual relationship, the U.S. Interagency Council on Homelessness has called on public housing authorities to ease their criminal record screening criteria. As well, HUD has recognized that screening is more difficult when, as often happens, an applicant's criminal history is mixed or marginal. HUD has said that public housing authorities should consider applicants for residence by persons with such criminal histories on a case-by-case basis, considering such factors as the seriousness and recentness of the criminal activity, the extent of the criminal activity, and any additional factors that might suggest a likelihood of favorable conduct in the future. In 2011, then Secretary Sean Donovan issued 2 letters to housing authorities and project owners. In the first letter, he reiterated the importance of second chances for people with criminal records and a commitment to helping ex-offenders gain access to one of the most fundamental blocks of a stable life, a place to live. In the second letter, he encouraged PHAs and project owners to use their wide discretion to allow people with criminal records to rejoin their families in public housing and the voucher program where appropriate. So the question that we have that's most often asked of us when we're working in the community is, what are HUD housing providers currently obligated to do? Because what we see is the policies do not match what they are currently obligated to do. So as Ron said, there are first the mandatory bans. A PHA and a project owner must deny admission to anyone who's ever been convicted of manufacturing methamphetamines on federally assisted property. As well, anyone subject to a lifetime sex offender registry. As well, current users of illegal drugs, abusers of alcohol, or persons who have a pattern of interfering with the health, safety, or peaceful enjoyment of residents at the property. And then finally, anyone who within the last 3 years has been evicted from federally assisted housing for drug-related criminal activity, unless they can show evidence of drug rehabilitation or circumstances leading to an eviction that no longer exist, such as the offending household member is no longer in the home. There are also discretionary bans. A PHA or project owner may deny admission for drug-related criminal activity, including for manufacturing, selling, distributing, use, or possession, For violent criminal activity, the use or threatened use of physical force that will cause serious bodily injury or property damage, or other criminal activity that would adversely affect the health, safety, or right to peaceful enjoyment of the premises by residents or the public housing employees. Now, HUD notes that there are a wide variety of other crimes that cannot be claimed to adversely affect the health, safety, or welfare of public housing residents. There are also limits on this discretion. Although a PHA or a project owner enjoy wide discretion, their discretion is subject to two important limits. First, time. Criminal activity must occur during a reasonable time before the screening takes place. They are also limited by the Federal Fair Housing Act and other civil rights laws. Granted, criminal records status is not a protected class under the Federal Fair Housing Act, but criminal record screening may nevertheless run afoul of civil rights laws. First, it could be by discriminatory treatment, where the criminal record is used as a pretext for race or national origin discrimination, or disparate impact, where there's a facially neutral policy that has an unjustified disparate impact on racial minorities. The racial disparities in the criminal justice system are well established, and the events over the last 2 years nationally certainly affirm this. The question becomes whether the disparities are justified depending on the policy at issue. I'm now going to turn it over to the report's author, Marie-Claire, to talk about our 4 main problems that we've identified with the criminal record screening nationally by project-based Section 8 owners and public housing authorities. Thank you.
Thanks, Kate. And thank you, HUD, very much for inviting us here today to speak about this report. This is an area that we've been working on for some time now, so the opportunity to address this agency on these issues is a very appreciated one. As Kate mentioned, there are 4 areas of concern that we found in our review of written admissions policies. And just to give you a sense of what we did, we looked at written admissions policies of over 300 programs across the country, ranging from big to small, and really took a look at what is the language that's in these policies and to see how they conduct their criminal record screening. And so what I'm going to do is briefly go over the 4 main areas and then delve deeper into each of them, as well as discuss possible concrete steps that HUD can take to address some of these issues. Let me put this down one second. So the first area that we see is the issue of unreasonable look-back periods. And in this category, what we find are public housing authorities and project owners that reach back far in time to get criminal record information that's usually stale, sometimes irrelevant to whether a person is going to be a good tenant. The second issue is the issue of the use of arrests in determining whether criminal activity took place. Arrest, as I'll discuss, a lot of courts have said that arrests are simply proof that someone suspected you of criminal activity and not necessarily proof of the criminal activity itself. So that raises some problematic issues. The third category, or the third issue area, is the use of overbroad criminal categories of criminal activity. So these are PHAs and project owners that take very, very broad definitions of criminal activity, and in the process sweep in a lot of behavior that is irrelevant to whether a person can satisfy their obligations under the federal housing programs. And the last issue is the issue of underuse of mitigating circumstances, where people either don't know that they have the right to present evidence of how they have been rehabilitated or how their criminal record is no longer relevant, or in cases where applicants do know, we have found instances where the housing authorities and project owners simply choose not to consider this evidence in deciding whether to admit a person. So turning to the first problem, we turn to unreasonably long look-back periods. Now, what the law says is that public housing authorities and project owners must limit their criminal inquiry to activity that took place within a, quote, reasonable time before the screening and admission takes place. And housing providers are also supposed to define what they mean by reasonable time in their written policies. Now, although we have this term reasonable time in the statutes, there is no real definitive guidance on what this term means. As advocates, we often use some guideposts on what may be a reasonable time. So sometimes advocates point to the fact that under the law, Congress has said 3 years is how much time you look back if a person has been evicted from federally subsidized housing for drug-related criminal activity. So sometimes you get the number 3 years for that reason. Other advocates sometimes like to point to the fact that HUD has listed 5 years as a reasonable time to look at serious crime. In the notice that suggestion is made, however, HUD within the same sentence says that PHAs and project owners may feel differently and may impose a different time. So everything's a little bit loose, and there's no real authority saying this is how you determine what a reasonable time is. Given the lack of definitive guidance, there are a lot of discrepancies in how housing authorities establish look-back periods. And so this chart goes through some of the broader practices that we've seen. So one common area that we found is that there are housing authorities and project owners that simply have no time limit on how long they can look back on a person's criminal history. So a sample of this would say, we will deny on the basis of a history of criminal activity, and that's it. And what this does is it really gives applicants no notice or no idea of whether an old criminal record, a minor criminal record, would factor into their application. And in turn, it discourages a lot of people from even applying in the first place because it sends the message that we don't admit people with records here. Related to the issue of no time limit is the issue of explicit permanent bans. And here we found some policies that specifically say that they would, quote, never, or that they would never take somebody with an assault or bodily injury conviction or arrest. Or that they would not take anyone who was ever convicted of certain criminal activity. So in these policies, the housing provider is explicit that these people are just off limits in terms of the housing program. Even when the housing authority or the project owner sets a time, that time can often be disproportionate to the activity at hand. As Kate mentioned before, I had originally written a report based on Illinois back in 2011 and had reviewed some project-based Section 8 policies there. And in that review, we found places that would deny people for 25 years, 40 years. That in and of itself is pretty long, especially, I don't know what the median age is of people applying for public housing, but I'm gonna guess that a 25-year or 40-year look-back period is pretty onerous. But we also found policies that denied people for 99 years and 200 years. So these are things that are written in an admissions policy, which they might as well just say don't apply. So, these type of policies exist out there, and they do give a very, very strong message about what the intent of the housing authority is. Even when it's not 100 or 200 years, we found that even something that seems relatively shorter than that, which is 7 years, we found that sometimes housing authorities give themselves the right to deny someone 7 years for bouncing a check. So there's a lot of disproportionate time limits there for people. We've also seen minimum time periods. So there's quite a few housing authorities out there that talk about a minimum of 5 years without setting an upper limit. And the final point that under this category is that there's a lot of confusion from applicants and advocates about what kind of activity they're actually looking for. What is it that a PHA is looking for within the look-back period? So there are many different points at which you interact with the criminal justice system, the main ones being arrest, conviction, and the completion of your sentence. And housing authorities apply their look-backs differently. Some say, well, if you've been convicted in this amount of time, then you do not come in. Some say if you've been released in this amount of time, you don't come in. And that is a very big point of confusion among applicants, and something that can really elongate a housing provider's look-back period. So given the extent of these problems, what can HUD do? One of the things that we really, really encourage and think would be very beneficial for housing providers and applicants in general is if HUD would provide detailed guidance on how to define reasonable time. This is, again, language that's in the statute, but there's just no real way or guidance on how to determine that time. And we're not asking for an across-the-board number that applies to everyone, because we realize there are differences in jurisdictions. But I think that, without any sort of guidance, that a lot of these look-back periods will continue to be overly long and keep a lot of people out. So what we've seen that seems like it may work are policies that have look-back periods that are based on the type of offense, by the severity of offense, and maybe also the number of offenses. So what HUD can really do in this area is provide guidance to help housing providers find what is a reasonable time limit for their jurisdictions. The other thing that HUD can do is to hold providers accountable when they fail to define any sort of reasonable time in their written admissions policies, and also when they include, obviously, unreasonable time limits, like 99 years, like 200 years, and even 45 years. I mean, these are things that you can find very easily within the written admissions policies, and there needs to be a message, I think, from HUD that this type of policy is not acceptable. Turning to the second problem that we found, deals with the issue of arrests. Now, what the law says is that housing authorities can deny on the basis of certain types of criminal activity being the operative word there. And as I mentioned before, many courts have concluded that arrests are proof of suspicion and also proof that you've been arrested, and not necessarily proof that any underlying criminal activity took place. What we find in a lot of policies, however, is that there are a lot of housing authorities that explicitly equate an arrest with criminal activity. And so what we have in this chart is a sample of housing authorities where they say if you've been arrested in 3, 5, or 7 years, just one arrest, then you will be considered to have engaged in criminal activity, regardless of whether this arrest ever resulted in a conviction or any sort of guilty finding. Now, setting aside the fact that using an arrest contradicts the statutory language of finding criminal activity, we also point out that there is a civil rights problem with relying on arrests. Arrest record screening disparately impacts a protected class, namely racial minorities. The USA, there's a lot of data out there about arrest rates, and I think that most recently, after a lot of the events of Ferguson, the USA Today did some investigations on the rate of arrests among African Americans and found that nationally the rate is 3 times that of the general population, and in some areas can be as high as 10 times the rate of the general population. So a policy like this that relies on arrests will have a disparate impact on people of color. Housing providers often will justify this disparity by saying that arrest record screening will protect the public safety, that they'll make the properties safer because they'll keep out people who are, for lack of a better word, criminals. However, there's evidence to the contrary. There are large public housing authorities, such as Los Angeles and New York, who have reported not relying on arrests and still reported that they are able to fight crimes in their jurisdictions. And as I noted before, arrests are not proof of criminal activity, so really they have no bearing on whether a person committed the activity The Shriver Center, we were involved in a case as amici a number of years back called Landers versus Chicago Housing Authority. And this, we think, is a good example of a case where a person had an arrest record and the court found that that was not sufficient proof of criminal activity. So in this case, Mr. Landers is an African-American gentleman. He applied for public housing in Chicago in 1995, and his name came up off the waiting list in 2008. So between 1995 and 2008, he went through pretty long periods of homelessness, and during that time, he also got an arrest record. He was arrested a series of times. None of them resulted in a conviction. They all resulted in dismissed charges. Nevertheless, the CHA, in deciding to deny his application, cited the arrest record as the reason why. And Mr. Landers, with help of his attorney, appealed the case first within CHA and then to this Illinois appellate court, which the CHA fought very vigorously. And the appellate court ultimately found where, as in Mr. Landers' case, there is only a record with dismissed charges. There was no evidence whatsoever that he engaged in criminal activity or that he was a threat to other residents. So the question is, again, we come to what can HUD do? Again, in this area, I think there is a strong need for guidance from HUD. Outlining, number one, the civil rights implications of arrest record screening, particularly under laws like the Fair Housing Act, and also guidance stating, again, that arrests are not sufficient proof of criminal activity, and that the statute really calls for proof of criminal activity as a basis for denying people access to housing. We also think that HUD can probably do more to enforce the civil rights laws, against housing providers that deny admissions based on arrests. So this brings us to the third category, which is overbroad categories of criminal activity. The statutes refer to 3 types of criminal activity where housing providers have discretion on whether to deny or admit. And Kate mentioned them earlier. They are drug-related criminal activity, violent criminal activity, and other criminal activity that pose a threat to the health, safety, and welfare of others. And just to just to re-emphasize again, the last category is not a catch-all. In order to really fit under that, it's supposed to pose a threat. Despite this enumeration of activity, some housing providers give themselves the authority to deny on the basis of all criminal activity, which sweeps in a lot of categories that have really limited relevance to a person's ability to be a good tenant. So I'll just go over some of the categories that we found. In Galveston, we had found that the housing authority had included civil disobedience that took place within the last 10 years. We have a number of housing authorities that denied on the basis of, quote, any activity that would be a crime on or off the property. In Little Rock, people can be denied for 3 years for misdemeanor convictions and 7 years for felony convictions. So between felony convictions and misdemeanor convictions, there's not really a lot of nuance. And in Buffalo, we found that the housing authority gave itself permission to deny on the basis of crimes of violence against people, against property, crimes that impose a financial cost, crimes that involve disturbing the peace, crimes that affect the health and safety and right of peaceful enjoyment of premises by others, drug-related criminal activity, and it gave itself the authority to consider any other criminal activity not listed. And it also had no look-back period. So basically, it's going to look at anything that you bring in, and applicants to that housing authority are going to get the message that they're not going to be welcome there if they have a criminal record. Related to the issue of denying for all criminal activity are policies where the housing authority will deny on the basis that a person has been incarcerated. We've seen a sampling of housing authorities that list the fact of incarceration as enough to deny. These usually come with short look-back periods. There's maybe 6 months or a month, but these policies usually say you can deny on the basis of incarceration. They don't really specify the type of offense, and they don't say that you necessarily had to have been convicted of anything. As a result, this often captures people who have been incarcerated because of pretrial detention, and that we find that problematic because a lot of times people have not necessarily are in jail before they have a trial because they're not able to make bail and they don't have the money to get out. Seattle Housing Authority, for example, denied an applicant on grounds that he had been released from a correctional facility within 6 months of his eligibility interview, even though the charges against him were ultimately dropped. So very sweeping categories like this have a very detrimental effect to applicants with records. Other housing providers provide very vague categories. So for example, they will look at your criminal activity to see if somehow you're a, quote, negative influence on other residents or if it evidences immoral conduct. We also find that a lot of PHAs and project owners, that they often deny people on the basis of felonies, and they impose felony bans on their applicants. Some are very explicit. Right here in Washington, D.C., the D.C. Housing Authority provides that it may deny admission if any adult member of the applicant's family has been convicted of a felony. Others provide very exhaustive lists, like AIMCO. AIMCO is one of the largest owners and operators of apartment buildings in the country and has a lot of project-based Section 8 properties. And they have a very seemingly complicated matrix with lots of different criminal activity on it. But if you really look down, if you really look closely, the policy basically comes down to no one with a felony record. And The examples they include are felony public intoxication, felony shoplifting, and felony theft by check. We even have one project-based Section 8 property that bars anyone who has been charged with a felony in the last 20 years, even if that felony was ultimately downgraded to a misdemeanor charge. Felony bans, like arrest records, can pose a civil rights problem. The rates of felony convictions are disproportionately higher for racial minorities. But the question in this case becomes, is a felony ban ever justified? And there will be times when it simply is not justified. I once had a client who we were trying to work with the CHA to get him into housing, but the CHA did not want him in because he had a felony conviction. The felony conviction was for felony shoplifting. In the state of Illinois, if you have 2 convictions for shoplifting under the amount of $300, the second one becomes a felony. This is the result of a lot of state legislators ratcheting up the seriousness of their crimes in a sort of tough on crime tidal wave that took over a lot of state legislatures. My client his crime was basically that he shoplifted from like a Walgreens, a local Walgreens, and the things that he shoplifted mainly consisted of household goods like soap and shampoo, that type of stuff. It's not really somebody who is going to pose a threat to others, but the CHA was very adamant that they weren't going to let him in. And so, the result is, the real life result, obviously, of these type of problems is that I had a client who had to sleep on the L at night in the winter because the CHA wouldn't let him in for shoplifting convictions. So in those situations, I feel like, in those situations, felony bans are way too broad and don't really even get at the issue that housing authorities and project owners are trying to get at, which is protecting the public safety. There will, however, and I acknowledge this, times when a felony ban will be justified. And so what we're calling for here is not necessarily that you never deny on the basis of a felony, but that the housing authorities and project owners enact much more narrowly tailored criteria for determining whether a person with a felony should be denied housing. So in light of that, we believe that HUD in this area can issue guidance requiring narrowly tailored criteria consistent with civil rights laws, that they can enforce civil rights laws against housing providers that ban particularly broad categories of applicants with criminal records, and that they also urge housing providers to provide more detailed and reasonable categories, because it's probably in the housing provider's best interest to do so. Otherwise, they do risk, I think, violating applicants' due process rights. So the fourth and final area that we found problems in is the underuse of mitigating circumstances. What the statutes say, or what the law says, is that in public housing, PHAs are required to consider certain mitigating circumstances: the time, nature, and extent of the applicant's conduct, and the seriousness of offense. PHAs may also consider factors that indicate a reasonable probability of favorable future conduct. So examples of this are rehabilitation evidence, attendance or willingness to attend social services, counseling, and program availability. In the other programs, including the Housing Choice Voucher Program and the Project-Based Section 8 program, HUD encourages the consideration of mitigating circumstances, but there is no formal requirement on these housing providers. What we have found really happens, or often happens, is that there's often no mention or explanation of mitigating circumstances in written admissions policies. As a result, a lot of applicants do not know that they have the right to provide this information. There was a study of formerly incarcerated individuals in Pittsburgh a few years back, and the individuals all of them knew very well the screening criteria of their PHA, but they didn't know that they had the right to provide evidence to show that their criminal history was no longer relevant. And one of the individuals was quoted as saying, "They said I'm not eligible until 2021." And I think this was done in 2008, so that's a long time from now. "They said I'm not eligible until 2021. I went in there 3 times, and it wasn't until my last visit that someone said I needed documents on rehabilitation to get in." So I think that there's a real a real gap in terms of knowledge of this right that applicants have. And sometimes, even when the applicants do know that they can submit evidence and when they actually follow through, the PHA or project owner sometimes refuses to consider it in a meaningful way. So there is a case out of Indiana County where there is a woman, a mom, who wanted to reunite with her son. And in that case, the housing authority decided to deny her admission because she had a drug paraphernalia conviction. She had provided evidence that she had completed substance abuse treatment, that she had completed therapeutic treatment, and also had completed parenting classes. She showed them evidence of ongoing drug tests that came out negative, and she also had letters from 3 professionals stating that she was committed to recovery and on the way there. And despite all of that evidence, the housing authority still denied her application. So given this type of story, I think there's a real need for HUD to emphasize to housing providers that mitigating circumstances are something to take seriously and to consider thoughtfully. In the public housing arena, they can remind PHAs of their legal obligation to consider mitigating evidence and also provide instruction on how to consider such evidence. And in the other federally subsidized programs, they could encourage housing providers to consider mitigating circumstances. HUD does that right now, so a potential additional step is to provide examples and best practices of what these policies look like. So a sample of what we've seen of housing authorities that do explain are certain factors like employment or participation in a training program, substance abuse treatment, and when substance abuse treatment has been undertaken by the applicant, some housing authorities will look at whether the applicant was under the influence at the time of the crime, whether the applicant has successfully completed therapy directed at correcting the underlying behavior, and whether there's an existence of a support network. And this is an interesting area because some housing authorities will look at whether there's people who support the applicant. Are there other family members? Are there community members? Are there people that the applicant can turn to help support that person? So other housing authorities also look at who is it that the applicant supports. Are they supporting usually probably a family? Do they have children? Are they taking care of their mother? There are some housing authorities that take this into consideration. And another factor that people consider or housing authorities consider are recommendations by probation officers, caseworkers, counselors, or other involved individuals who can attest to the person's progress beyond their criminal history. I also wanted to note that another potential example of a best practice is that in 2013, the Housing Authority of New Orleans proposed changes to their criminal background policy where they would prioritize mitigating evidence in the application process. Typically, what happens is that a person submits their application, they're denied, and then the onus is on them to request an appeal and then present mitigating evidence. What New Orleans has proposed is to allow people to present that mitigating evidence before the final decision is made. And so that timing allows the decision maker to get the full picture. And also in New Orleans, they have proposed making the decision-making process a, quote, individualized assessment based on the totality of the circumstances. So again, reflecting that there is probably a lot of information that goes into whether this person's criminal record will be a factor in how they succeed as a tenant. This was back in 2013. I'm not quite sure exactly where Hano is on these changes, on adopting these changes, but I think that at least the language provides a really good model for other housing authorities. So just to give an overview of the recommendations we have, we think that there could be guidance, especially by FHEO here in HUD to housing providers, that aggressive criminal records policies can run afoul of civil rights laws. The EEOC, as some of you may or may not know, had issued similar guidance in 2012 that advised employers of the civil rights implications of criminal records screening in that area. And I think that it has reinvigorated a debate amongst that employment community about criminal records screening and how to do it in a way that conforms with the law. And I think that a similar guidance would be similarly beneficial in the housing arena. In addition, this is something that is sought not only by advocates and applicants, but also by housing providers. There was, when HUD opened up comments for the fair housing regs, for the disparate impact regs, there was some comments about some guidance on this issue. HUD can also issue guidance on reasonable time, which was the first problem we discussed. We think that this would go a long way to staving back a lot of the overly long look-back periods that we're seeing. HUD can ensure that PHAs and project owners adhere to the existing statutory and regulatory mandates imposed on them, such as the duty to consider mitigating evidence in public housing, and that their written admission policies should reflect those actual policies, and to hold housing providers to their duty to comply with civil rights laws and to mandate compliance. Finally, I discussed all of these issues as very discrete issues, but they often work in conjunction with one another in the same property. And when that happens, it creates seemingly insurmountable barriers for people with records. And so I just wanted to leave you with a case that's coming out of New York. It's called Fortune Society versus Sandcastle Towers Housing Development Fund Corp. It's a private landlord that bans people with arrest records and conviction records. So it's not necessarily under the jurisdiction of HUD, but I did want to give you just a sense of what it looks like when all of these issues come together. Here, the private landlord pretty much has a permanent ban and is not going to let anyone in with a criminal record, so there's no sort of reasonable time limit. They look at what they consider to be all criminal activity, so the issue of arrests comes up. There's also, and because they're looking at all sorts of criminal activity, you have a very clear problem of overbreadth in its categories, and they will not take any evidence of rehabilitation. So obviously this is not within HUD's jurisdiction, as I said before, but HUD has the ability to exert wide influence in this area because a lot of on the private rental market, they are looking at what it is that HUD does, and especially if HUD issues guidance on something like the Fair Housing Act, which applies to private and public alike. There is an opportunity here to really open up, to take the spirit of Secretary Donovan's letter and to really spread it to the housing market so that the effects can be felt by a lot of the people who have criminal records and who are ready for housing and to move past those records. So again, I thank you very much for the opportunity to speak here. We're going to have a Q&A session, and I think I speak for Kate and I where I say we really hope this is the beginning of a dialogue with HUD on this issue. Thank you.
Thank you very much. So we're going to open it up for questions. Does anybody have questions, comments, challenges? Where's that? Yes, thank you. Ladies first.
You have them go to the microphone.
Yeah, could you please go to the mic? Thank you very much.
Hi, I'm Lisa Flood. I work in public housing. One of the challenges I foresee is just doing a widespread study of all the existing policies in the ACOPs. It seems like that would be a great undertaking. And if we were to encourage PHAs to change these policies, how do we ensure that they do? How do we collect this information? It just seems like a lot.
Okay. So do you want to respond to that?
So our sample size was probably, well, like I said, probably around 300. A lot of it, I mean, I think I agree with you. It's probably a pretty big undertaking because some of those, a lot of those were things that were available online.
And then they keep changing.
And they
So
keep
we actually intended to have the report out in 2014, and then we would be on the eve of releasing it, and they would change. So it is somewhat of a moving target. I do think if you look at the EEOC guidance at the end, they have best practices. And I think that HUD issuing best practice language would be a really big start to that. And then potentially doing some sort of audit. If you can't cover every PHA, do an audit, of both small and large and medium-sized PHAs to get a sense of if they are in fact changing their policies to reflect what you're recommending at HUD.
Mm-hmm. Yeah.
Good. You might as well stay up here.
Hi, my name is Reginald Williamson. I'm a staff attorney in the area of community reentry here in DC. The first question is, certainly part of the issue is simply informing the public of their rights. Is HUD open to providing maybe a big banner or a leaflet or some sort of notice that is required to be at any PHA's office for the public to be able to see in terms of their rights when they come in, or providing some sort of form that is required to be a part of the application to inform people of their various rights with reference to records, criminal records? That's the first question. Second question is, EEOC had investigated BMW and dollar stores with reference to criminal records. Is there a mechanism within HUD in terms of filing a complaint about a PHA that would initiate an investigation by HUD into that particular PHA?
We're not with HUD.
We're not with that. Are you sure? So can you repeat the second question about BMW? I'm sorry.
Yeah, EEOC began an investigation into BMW and dollar stores in terms of their handling of criminal records.
Right. Right.
And the question is there a mechanism available to file a complaint against a PHA that would be submitted to HUD, to HUD, to then initiate an investigation into a PHA in terms of how they're handling records?
So, I'm punning on this question, just so you know, right? But I think that question goes to our Office of General Counsel, right? Right now, housing authorities have discretion, right? And they have discretion to do, really what the 99-year housing authority that denies someone for 99 years, HUD says they have discretion to set the rules. Whether it's right or wrong is a whole nother question, right? I absolutely agree that's wrong, right? So HUD has to do something about discretion and rein it in. And I think that what HUD can, whether HUD or Congress, because I think you have to do that by statute, would actually say, no, you may not ever, say 30 years, 20 years, or whatever, right? I think that, and again, I'm not an attorney, right? So I think that goes to regs, and I think that goes to statute.
But
There's some lawyers out here.
Could there potentially be a Title VIII complaint filed with FHGO, I guess is the question on the issue of if based on intent, right? Disparate treatment or disparate effect, right?
So you're asking whether someone can file
a Title VIII case.
file a case, and my answer would be, of course they can, right? Whether they would win or where HUD would stand on that, I don't know the answer to that.
And then I think the first question was really important too, and this is certainly, I just came from a conference on Monday with the faith community in Chicago, and we always have these slides about what the rules are, because they're so divorced, right, from the reality. But the reality is actually even worse, or the myth, in the community.
Right.
That there are perceptions that if you've ever been incarcerated, not only can you not be ever admitted to public and subsidized housing, you cannot enter the property. I mean, that's how far it's gone. So I think this point is really important about HUD issuing information about what, in fact, the rules are, not just for providers, but for potential applicants, because I think they self-select out of the process. They don't even apply because they believe they won't be considered. Unfortunately, the report validates some of that, but not in all instances. So I think it is critical if HUD is able to issue good information to talk about those issues.
Okay, so let me tell you something that we did do. When the letter came out, the Sean Donovan letter going to the 3,200 housing authorities and to multifamily agencies, I read, again, it's a letter. Housing authority could very well take that letter, throw it away, right? But what we did as part of the Reentry Council was we developed a myth buster, right? So it's not only a letter that went to the housing authorities, it's a myth buster that is a public document that, we actually looked at a prison, right? And there was a prison, and they had an education facility. They had myth busters on their table, right? Including the myth buster that we designed to coincide with that letter, right? So it is definitely possible that HUD could do something. Once HUD moves in this area, we can get the public information out as well. Yes, next question, someone else?
Before I came here, I worked for legal aid briefly. One of the things of Arkansas is we had a criminal conviction statute which didn't have jail time. Are they been denying people based off of all criminal convictions, regardless if it involved jail time? Or has it only been primarily jail time?
I'm sorry, can you repeat the question?
Okay,
I had a hard time
criminal
hearing
conviction statute that says in Arkansas that if you do not leave a premises, you do not pay rent, we won't jail you, but you're going to fine you $25 a day. It's a criminal conviction misdemeanor. Have you seen that problem as well, where unpaid misdemeanors, which only a fine, have been used as a bar to getting into these places?
Misdemeanor convictions that result as a consequence of not paying a fine.
They're a misdemeanor, but they're a fine misdemeanor. They're not.
Yeah, I think the majority of the policies that I see don't really differentiate about your sentence. The only exception to that is where a housing authority or project owner specifically mentions incarceration. Mostly they're concerned with conviction and arrest in general. So there's not really a lot of emphasis on what your sentence was.
Okay.
Hi, my name is Casey Weissman-Vermeulen. I'm in OGC Fair Housing. I have a question whether, sometimes housing authorities are dealing with folks that are just coming out of prison, but sometimes, these are people who have been out for a while and they still fall within the look-back periods if they're particularly long. In those situations, did you find that housing authorities would look at, where they had been living before, like, and what their record of tenancy was in those places, prior to coming up on a waiting list, perhaps?
I think a lot of times that the housing authority, at the first cut, they're just looking at whether there's a conviction or an arrest that falls within the look-back period, and that they'll determine whether to deny or admit based on what's on that piece of paper, like on the record. And then, your history as a tenant might probably should factor into mitigating circumstances. But again, that's sort of the person applying A has to know and has to present that evidence, and then the PHA and the project owner has to consider the evidence. So it's not something that I don't get the sense that it's something that they necessarily consider at the first cut.
Hey guys, thanks for coming. I'm Emily Turner and I'm an OGC. Just two quick comments and then a question. On your question regarding the convictions, I think one of the problems, at least that I've seen, is when housing authorities are pulling criminal background information when they run their check, or whoever the third party is that runs a check, they get a sheet that doesn't have a lot of lengthy backstory as to what the crime was, what the misdemeanor was, what the felony was, what the charge was, right? So it doesn't always give an exhaustive review of what that means. So I think that's one of the reasons why it's so critical for some movement in this area. Is it might say arrest, it might say misdemeanor, but it doesn't define what, right? So my answer to your question would be probably a misdemeanor that is based only on a financial on fines could absolutely be grounds for denial. Another comment was, and this is to add on the Hano side, I do believe Hano is still trying to figure out what to do with the policy that they had come up with, but Cook County Housing Authority in Chicago has done exactly what you're saying, where they have added language both to the application itself, saying if you have a criminal background and you check yes to this, just know that that is not we do not have a blanket ban. You will be allowed to present your circumstances before we decide. And I think they have also changed, I believe, their admin plan on the Section 8 end, but I think also their ACOP on the public housing end. And when speaking to them, it was really great in that they had said they're actually saving money. Not only do they think it's a best practice, but they're saving money on the appeals process, on the administrative end, because by allowing people to present their story on the front end, they're not seeing the appeals that they used to, where frankly people are just, again, presenting their story, right? Presenting what they've done, why they think that whatever issue that might have been isn't going to relate to their tenancy, et cetera. So just wanted to add that. And then my question is, when talking to housing authorities, again, I know you had a huge slew of housing authorities that you've interacted with, or at least been able to pull some information from the internet. For those that you have been able to speak to, have you gotten just wondering with I think it's upward towards 100 million people with some sort of record at this point. Is there an acknowledgement, just looking for what's the general tenor of the housing authorities that you've been able to talk to on, is this an issue, is this something that they're seeing or project could be a problem, and would they be willing to revisit their policies if, for instance, HUD were to come out with a little bit of guidance?
I think it's a mixed bag. You have some housing authorities that are cognizant of this general movement to ease barriers for people with records in all facets of civil life, and so I think you have some housing authorities that are willing to sort of take a look, at least, the fact that Hano kind of came up with this background check or revised background check policy is evidence of that. And I think there are others that just are a little nervous to change their background check policies and don't necessarily feel like they have to, because there has been sort of emphasis on the fact that they have a lot of discretion. And so I really think it's a mixed bag. I think there's potential for movement, and I do think that HUD is needed to push a little bit for the movement to have some momentum.
And I think there's a lot of competing pressures. You know, with the local housing authorities, they are oftentimes getting pressure from local government to come down hard on crime. And so I think it is important that HUD set the tone to address that pressure from the local governments, who are oftentimes then appointing members to the Housing Authority Board, hiring the executive director. So there is that present conflict. I also interact quite often with property managers, particularly in the multifamily side, project-based Section 8, and they really feel that their hands are tied, that these are corporate policies. They see people, they see the applicants. Many times they know the applicants, and they know that they have the ability to be a good tenant, but the corporate policy that's been set that may be across state lines is not something that they have the ability at this point to alter.
Okay, great. Sorry. Calvin Johnson, Policy Development Research. Excuse my voice. I have just two quick questions. The first one is that you said that you have 200 or 300 housing authorities. 300. First question is that, is there a way, I understand that the sample was probably done in a way that wouldn't allow us to draw any inferences or anything, but is there a way that you can look at kind of the classes of practices and the characteristics of the residents to get a sense of, again, not to draw any inferences, but to get a sense of whether these are tied to some underlying issues associated with the social and demographics of the residents. That's one. The other one is that it seems to me that this is an area where people are just kind of risk averse, right? I think that there is some momentum to understanding that folk go to prison and they will come home. Folk go to jail, they'll come home. Mm-hmm. There is also the acknowledgement that the person who may be cleaning your teeth or, actually sewing up a wound could actually have a criminal record. I mean, there's some acknowledgement that these are our neighbors, these are our teachers, these are our doctors, our bankers, our bus drivers. So it seems to me that there is already some public acknowledgement that second chances are well worth it. But the challenge is getting the right people to the table. So I have a question, and you don't really have to answer it. What would happen if we were to get public housing executive directors, owners of the project-based housing, get chief probationers and parole agents or officers and correctional facility leaders who are responsible for transitioning planning in a room just for a discussion? What would happen if indeed these issues could be just put in front of them so that you have folk who are not expert in one thing, but you have a caucus of people who deal with these issues from a number of different angles. I'm not certain whether that's happened, but I can tell you that it's a very powerful way of letting folk know that they're not in this alone. And I suspect that a lot of it is folk are risk averse, and they feel like that if anything goes sideways, that it's on them.
Right.
So let me just say that there are a number of housing authorities who are actually doing something in this area, right? Which is very promising. New York City has a pilot, and in that pilot, they have agreed to take 150 folks with records if they have someone in public housing who's willing to say, yes, I'm willing to have this person live with me, right? So they're screened by a community-based organization. They go to the housing authority, and housing authorities agreed, okay, folks will come in up to 150. If they mess up, the family will not lose their apartment. Their rent is not calculated for those 2 years, and then after 2 years, they will be put on the lease. They're also case managed, right? So New York City is doing it, Chicago's doing it, LA is doing it, right? And we're trying to take those examples and push them out because you're right, there are 700,000 folks coming out of prison every year. And when I first sat down with the Reentry Council, everybody turned to me and they said, you know what we need most? Housing. And they looked at HUD, right? So we know that there is this huge need, and we're looking at examples like NYCHA, New York City Housing Authority, and Chicago, and Burlington, and New Haven. And we want to spread those examples. And I know we have to do more. We have to do more, but at least we have to spread those examples.
Hi, I'm Libby Cochran. I'm currently on rotation on the Housing and Services team in the Office of the Secretary, but my permanent office is multifamily housing. You'd mentioned that LA, and I think it was New York City, have some policies in place around arrest records. I was wondering if there's any data, if you're aware of like any data or evaluation that has shown that you don't have to be quite so draconian and you can still prevent having, you know, violent offenders committing offenses on your property?
I wish there were. I don't know if you have researchers that are interested in HUD, but I don't think that there is a lot of broad studies like that. There have been some studies about people with records in the supportive housing context and how their criminal record is not a factor in whether they fail or succeed in the program. I know one is by Daniel Malone. I don't know what the title is off the top of my head, but he has one. I think there might be some others, and if you give me your name later, I can send that to you. But there's not quite anything yet that says, you know, these PHAs let in these people with these records, and so, you know, they are still fighting crime the same way. I mean, most of that is self-reporting from the PHAs themselves, but no real research yet. Mm-hmm.
I just wanted to add real quick on that note, there's a C-sharp, I think it's a C-sharp program in Colorado where they're finding, I don't think it was through the Denver Housing Authority, but they found in the last, I think very recently, that since they have launched a program where people who have gone directly from incarceration to homelessness and then placed them into housing, they've reduced recidivism by, I think it was 35%, don't quote me on that. But I think those sorts of things are starting to unfold now that programs in the last few years have started to launch. But I wanted to mention that just because I think it's a great example that people can refer to.
Mm-hmm.
Hi. First of all, thank you all for coming down here. It's very informative. I said thank you for coming down here. It's very informative. My name is Brian Ferguson. I'm with the DC Office of Human Rights, where I'm the lead investigator for the Fair Criminal Record Screening Act that deals with employment in the city. And so my question, and to the gentleman's point about there needing to be a statutory solution to this, considering that there are like different jurisdictions and municipalities, PHAs that have varying restrictions because of the discretion that takes place. Is there a particular PHA or municipality that can stand as a practical or like a shining example of, you know, what are the best practices and what is the efficacy of, you know, of what they're doing and having more fair practices? That's my first question. And the second question is, what is the effort to target these specific legislatures that would need to, you know, push the change to see one of these, you know, small municipalities or a couple of these PHAs get to where they need to be so that, you know, they can serve as an example for a national, more broad change?
Do you know through your research?
Oh,
someone
so
stands out?
I mean, in terms of the statute, I think when Ron was referring to the statute, he's probably referring to the federal statutes that govern the programs, and you know, we try to think of ways a little bit short of that, just because Congress right now is just not really able to do much, and so in that respect, that's why we really focus on HUD, because I think there's a lot of potential to do a lot of changes short of a statutory change to really help people, and I think a statutory change is definitely something like long term to think about, but I think first we have to get a Congress that will work together on these issues, and then you asked about potential models, and I think I don't think that there's necessarily one PHA that stands out, because we looked at a lot of different types of problems, and everybody has a little bit of a different variation on a problem, but we do have, and the report delves in this a little bit more. There are some PHAs that do some things that we really like, and I think, for example, the area of mitigating circumstances, there are some PHAs that really do a good job of making sure that people know, not only that there's mitigating circumstances, but what does it look like, what can I bring forth, and I think maybe that, again, we really see HUD as a leader on this, to be able to canvas some of that information and then distribute it under the banner of HUD would really, I think, show a lot of other PHAs look, this is something that we could do, we could apply to our own programs. I don't know if that answers your question.
Yeah, no.
Okay.
Okay, thanks.
Okay, sure.
So I'm looking for other questions and not seeing any. I'm going to thank Chicago for lending us you for a day. We really appreciate you coming in here. This will go on, this will be archived so that people will be able to see it and share it. And HUD will definitely listen to what you've presented us here, and we will make changes. I'll commit to that. So thank you very much, everyone.